Hello and welcome to our employment webinar on a number of issues, including can you hold a disciplinary hearing during lockdown? I'm Julie Bann, I'm an employment partner here at Sharpe Pritchard, and I'm going to be joined today by our trainee Alex, who's going ably covering a number of the issues that we want to cover today.
Hi everyone.
We've got 30 minutes and we've got quite a lot of things to cover, and so we're going to give a broad brush approach to a number of the issues, and then if there's any issues that you want to look at in any more depth, please let us know and we can do another webinar and just focus on those issues. And we will have questions at the end. You can put your questions, type your questions to us, and we can look at those at the end and we can go from there. So if you bear with one moment, we'll start this going. Bear with one moment, can't get my slides to click. Sorry, I do apologise, I'm struggling to get my slides to click across. Is there anything you can do for me, Alex? Can you get them to move?
No, I'm afraid I can't.
There. Right, we've gone on too far. Bear with one moment, let me just go back. No. Right. Right, do apologise for that, my IT ineptitude. We're starting with the subject, managing internal procedures, and what I mean by this is disciplinary procedures, grievances, performance management procedures, even absence management procedures. And everyone is struggling with this process. How do you actually manage your staff at the moment? You may have staff who are working from home, so it's harder to supervise. You may have staff that are key workers that still have to go out, but it's harder to supervise because your managers are working from home. Or you may have staff on furlough. And a number of things can arise during this period of time, and they absolutely have done from the discussions we've had with our clients. ACASA produced guidance on disciplinary and grievance procedures during the coronavirus pandemic, and I put a link there for you to have a look at. One of the key things that I think you need to think about very, very carefully is having a consistent response to the issues, irrespective of the pandemic. If you're going to change the way that you respond to certain conduct issues or performance issues, you need to have a very good reason to do so. Because basically, two of the key things that come out of most tribunal cases from claimants are that poor communication, they didn't know what was going on, or they feel they were treated unfairly in comparison to how other people have been treated. So it's really important that you have a consistent approach, and that means you can still have a consistent approach during the pandemic to any conduct issue or any performance issue. You want to put in place processes to manage your employees working from home to ensure that the communication is there, so they're well aware of what is expected of them, and you're managing that on a regular basis and you're communicating with them if things are going wrong. If you do have an issue that you feel you need to instigate your formal process, you need to decide whether you delay the actual process, or the investigation or the grievance hearing or the disciplinary hearing until such time as you can meet in person, or whether you think it is actually more fair and reasonable to proceed with the process and manage it during the virtual way that we are doing a lot of our work at the moment. In looking at that, you need to consider the impact on the employee's well-being. Now, this can work both ways. For some employees, delaying the process could escalate their stress and anxiety. For other employees, actually, the idea of going through a process virtually and having Zoom meetings and trying to get their point across would inflame the situation even further. Consider it carefully and discuss your proposal with your employees. So what the issue is and how you propose to deal with it. Keep in mind that you should continue to follow the ACAS Code of Practice, even if you decide that there are exceptional circumstances why you are not following your current processes. The ACAS Code of Practice is still going to be applicable throughout this process. By that I mean a three-stage process of an investigation, a disciplinary and an appeal. If your workplace is open, so you still have an office in which you can go to hold your meetings, then consider if you can hold the meeting fairly and safely, which means abiding by social distancing requirements and complying with government's public health guidance in terms of attending such matters. In addition, you should also consider whether it's fair to ask your employee to travel to the workplace to have that meeting, bearing in mind the issues that they may have in that commute. If your workplace is closed, then you have to decide, as I said, balance the urgency of the issues with the impact on the employee. Propose a plan of action as to how you're going to deal with this, and consider any reasonable objections that are put forward as to your proposals. And I mean reasonable, because there may be a number of times where you have a disciplinary matter, and it's quite likely that any employee is going to object to you pursuing it and want to delay that as long as possible. That in itself wouldn't necessarily be reasonable. Consider if everybody that's going to be party to the process has access to required technology and the relevant documentation. And by that I mean you can ensure that you can get the documents to the employee for them to be able to access while you're on the call. It may be that they don't have a printer at home. It may be that you need to post those out. You also need to consider whether you need to get that documentation to anybody that is going to be the employee's companion. They still have a right to be accompanied, which I'll come to in a little bit, but that companion should know what the issues are to ensure that they can support the employee properly. If you're aware that your member of staff has a disability that could be impacted on having a meeting at this time, consider reasonable adjustments. Don't make any assumptions as to how this pandemic may be affecting them. This is about consultation and agreement as to how you want to proceed. Right, if you've got staff working from home and you're planning to have a Zoom meeting or a Teams meeting, whichever network you use, do they have somewhere private to participate in that process? Do they have childcare arrangements, which means that it'd be very difficult for them to concentrate on something that could seriously impact on their employment? If you've got employees on furlough, ACAS say you can proceed if the employee does so willingly. And I would suggest that in this situation, it's a reasonable instruction to ask an employee to proceed with an investigation. It has been made clear by the government in their guidance that an employee can accompany another to a hearing as a representative while on furlough. And as far as I'm concerned, if that is the case, then an employee on furlough can also be asked to attend a disciplinary or a performance improvement process. As I say, look at those people that have disabilities and whether you need to accommodate that. And we look at the right to be accompanied. Now, I know that a number of trade unions have raised objections about processes continuing during the lockdown and objecting and refusing to participate in such matters. This makes it really difficult for you to go ahead. If your employee is a union member, then they have a right to be accompanied. And I think in that circumstance, if you cannot persuade them that delaying it will impact on your ability to investigate it fairly, then I think you would have to delay it. Right, moving on to managing absence. You need to be flexible in the evidence that you require of your employees during this period. It's likely with the lockdown easing now that they're going to have more access to the GP, but over this period of time, it's been really difficult for employees to access the GP to get a sick note. And therefore, you need to consider whether you change what you require of your employees during this period of sickness in order for them to be eligible for sick pay. In addition, we also suggest you look at your absence management policy, because you may well have a situation where a set amount of absence over a given period of time would trigger your absence management process. You might want to consider disregarding any COVID-19 related absences for the purpose of this absence threshold. I'm not saying you have to, but what I would suggest is you look at it and you make a decision what you're going to do, and then you can apply that consistently to all members of staff. So what about ongoing procedures? Now, we've had this on a number of occasions come up, and one of the concerns is, can you continue to manage any performance concerns or disciplinary concerns fairly? If you've got existing warnings in place, and by that I mean you've told your employees what they need to do to improve, and you've got a period of review, and that review period is coming to an end, it may mean that existing warning is due to expire. If you are unable to proceed with the matter virtually, so via online meetings, then I suggest you write to the member of staff. You make it clear a summary of what has happened to date, what you expected of them. If you still have concerns, put those in writing, because they need to be aware of what the issues are, and explain that because of the ongoing lockdown, you're not able to have that next meeting. It is going to be delayed, but the existing warning is also going to be extended until such time as you can deal with it properly. Right, in managing your return to work, you have an obligation to provide a safe place of work. That means you assess the risks, including the risk of travelling to work. You set up a system to manage the risks, taking into account government guidelines, and you implement that system. I would suggest that you start consulting with your staff, trade unions if you recognise them, employee reps if you do have them, as early as possible about how you're going to manage this. There is a huge amount of anxiety about returning to work and returning to normal life after lockdown, and I would suggest that the sooner you have those proposals in place, that you're talking to people, that you're communicating with them, the sooner you can alleviate that anxiety and you can get people back on board. If there are adjustments to the workplace, so it may be that you can't have as many people in the office as you usually would do, or there are ways that you're going to manage that, then you need to propose those. And also consider a phased return to work, staggered hours, so people can avoid rush hour, or using the flexible furlough, which is coming into being as of the 1st of July. Now, if you're a local authority, I appreciate you probably wouldn't have been able to use furlough over this period of time, so this won't apply to you. But we've recently just had guidance out, I believe as of today, on the flexible furlough scheme, which I'll just pinpoint in now whilst I'm on it. You can participate in this amended job retention scheme if you've already made a claim for the particular employee by the 31st of July, and so that employee had to be furloughed for a minimum of 3 weeks by the 10th of June. So we're basically, this is only for people who are already on furlough in some shape or form by that period of time. You need to have a requirement between an agreement between the employee and the employer as to how the flexible furlough will work. That has to be in writing, and you have to retain it until the 30th of June 2025. And the guidance sets out a huge calculation of how you pay people and what you can claim for. And I can't go into that now because we just don't have time, but that's something we can address at a later time. Just going back briefly to this slide, I've said there the working from home arrangements. It's likely when you went down into lockdown, you did so urgently and you had to do immediately, and you just moved people to working from home. If people are going to continue working from home for any period of time, you need to review their working from home arrangements. Make sure that they can work safely, that they have workstations. That means that they're appropriately risk assessed, accommodate their needs in terms of what childcare arrangements they have and when they can work, keep in contact with people, make sure that they're not isolated. So in managing return to work, you need to consider put your safe place of work in, a system of work in place. But what about people that are vulnerable? And by this, I mean those that are on the specific list of people that are vulnerable that are set out by the government. Can you offer them a safe place of work? Or can you ensure that you are not putting them at a greater risk? If you have concerns about this, and this has to be something that you do in consultation with your members of staff. I keep going on about that, but it's so important. They could remain on furlough until such time as you feel you are able to offer them a safe place of work, and that is should be subject to regular review. You want to consider whether there's any other way of paid leave you can give them, or if they can continue to work from home with the right amount of support. I've seen quite a number of occasions recently where GPs have given notes to employees to say that they are not fit to work because they are susceptible to COVID-19 due to pre-existing conditions such as asthma. I've seen it on one occasion. Consult with your member of staff about this. Consider carefully how you can deal with it. See if you can manage their return in a safe way. But if they've got a sick note, then you have to abide by that, and it may well be that they remain on sick leave and on sick pay until such time as they feel fit to return to work. As I say, flexible furlough may well be your friend in terms of dealing with this, and I've gone through that already. Right, can an employee refuse to return to work? Well, this is a big issue, and you may find that whatever system you put in place now, some staff may be unwilling to return to work for a variety of reasons. As I say, there's a huge amount of surveys that have gone on recently, and anxiety and depression has escalated through the roof over this period of time, and people will be very anxious and maybe concerned about that return. Speak to staff about their concerns and see if you can resolve them together. Consider reaching a compromise. It may be that you, as I say, you can alter their hours to avoid peak times, return to work on a phased basis, allow them to continue working from home for a limited period of time, allow them to take time off for annual leave if they haven't taken all their annual leave, and ultimately, if you are satisfied that you have a safe place of work, that there is work that they need to do, so they can't remain on furlough because their job is there and they need to return to work, then the other outcome is you put them on a period of unpaid leave, but that should be continually subject to review. Right, at that point I'm going to pass over to Alex, who's going to look at data protection considerations.
Thank you so much, Julie. In terms of data protection considerations, I think at the outset it's worth emphasizing that the data protection regime doesn't actually preclude remote hearings or working from home in general, as we know by now, but adequate security measures should be in place just like at the regular workplace. Recording disciplinary or grievance hearings must be done in line with the data protection regime, and you should consider, for example, security of storage for such recordings, limited and authorized access, and an audit trail of ownership, access, and usage. As part of a safe return to work, as an employer, you might decide to collect health-related data from your employees because you might consider that this is necessary in order for you to comply with your obligation to provide a safe working environment. You must remember that the principle of data minimization will apply, and more data than necessary should never be collected from your employees. You must always have a lawful legal basis under Article 6 of the GDPR for processing of personal data. Legitimate interest ground is likely to be appropriate for both public and private employers, and the public interest basis is likely to apply to public authorities. Because health-related data is a special category of personal data, you must also meet one of the Article 9 conditions for processing. And as an employer, you are able to process such data under Article 9(2)(b). If you are relying on Article 9(2)(b), then you should also meet the associated condition in the UK law, which is set out in Schedule 1 of the DPA 2018, namely where processing is necessary to carry out obligations and exercise specific rights of the employer and your employees. You must always remember that conducting a data protection impact assessment is good practice, and it might well be required under Article 35 to conduct one. A number of questions have been raised around temperature checks, and whilst this is not technically incompatible with the data protection regime, provided that you've got sufficient safeguards in place, you must remember that this is not part of the UK government's current advice on making workplaces COVID secure. And the WHO also noted that asymptomatic cases might be missed and temperature checks might also yield false positives. Given its limitations in detecting individuals who are truly infected with coronavirus and the potential compliance obligations that might attach to it, temperature checking might actually be more trouble than it's worth. If there are any specific data protection questions, I'm sure our data protection colleagues will be very happy to assist you. Moving on to the next slide, we've heard a lot about track and trace system, and you might be aware that recently the government admitted that the original track and trace app was not fit for purpose. And at the moment, the Google and Apple model is being considered, which is not even close to being ready yet. Generally speaking, the idea of track and trace is that people with symptoms will contact the NHS and request a test. Because of the symptoms they're experiencing, they will initially self-isolate for at least 7 days and will wait for the test results. If the test comes back positive, the NHS track and trace service will notify the person in question, require them to self-isolate for further 7 days, and request details of the people they have been in close contact with. The tracers will then contact those people and require them to self-isolate accordingly. What this means for you as an employer is that the category of people required to self-isolate will likely expand, and this will in turn result in increased absences. As an employer, you must establish and communicate a consistent and fair policy in the workplace in relation to employees who are required to self-isolate. And this needs to be done irrespective of the national track and trace system. You should consider allowing employees to work from home if it's possible at all. And if it's not possible, you should consider allowing your employees to take annual leave, whether paid or unpaid, or sick leave. If these options are not feasible, you should keep in mind that self-isolating employees will be entitled to the statutory sick pay at a minimum under the new amended regulations, but people might prefer to go on annual leave instead, given the rate of the statutory sick pay, and you should be ready to allow this as well. You should also consider revising and increasing your sick pay entitlement, because levels of the statutory sick pay might actually discourage people from informing you that they have been required to self-isolate, and this in turn might result in greater risk of infection in the workplace and beyond. If you offer contractual sick pay, which is greater than the statutory sick pay, then you should consider if this entitlement should also extend to self-isolating employees. Once an employee discloses to you that they've tested positive, you must consider your health and safety obligations and whether you should inform other employees that they have been in contact with the colleague with symptoms. However, you must never disclose more information than necessary. This goes back to the data protection considerations and the principle of data minimization. In terms of employees who are self-isolating because of the symptoms that they are experiencing but haven't yet been diagnosed with the coronavirus, you should consider notifying other employees who have been in close contact with them. And whilst they will not necessarily have to self-isolate, they might want to take extra care to, for example, avoid contact with vulnerable people. You should also consider whether it warrants a disciplinary action under your policy if an employee is requested to self-isolate by the track and trace system and doesn't. Moving on to the next slide, and in terms of whether you can actually require your employees to use the tracing app once it's introduced, the answer is technically yes, but it might actually be very useful where your workplace is one in which social distancing is difficult to guarantee. However, arguably, the app should be used at all times for it to be actually effective, and it might be unreasonable to require workers to use the app outside of work hours. You should also remember that you're relying on employees to honestly self-declare that they've been contacted by the traitors and are required to self-isolate, so you don't actually have any real control over the effectiveness of the app. You should also remember that the track and trace system comes with considerable data protection implications, and you must remember that if you intend to process any personal data produced for the employee's use of the app, then you will have to have lawful basis for doing so and be able to demonstrate your compliance with the data protection regime. You have to be also satisfied as to the data security of the app itself if you're going to insist on employees using it and sharing health data with it, which, as I mentioned before, amounts to special category data.
Okay.
Moving on to the next slide, we will now look at managing annual leave. You will know that the most restrictive lockdown coincided with Easter and a number of bank holidays around which people usually take some days off, but didn't this year due to the coronavirus. It is likely that a lot of people will still have most of their annual leave entitlements unused, and you should be thinking about how to manage this going forward. You can still require employees to take holiday at a particular time, and you must tell staff at least twice as many days before as the amount of days you need them to take off. So if you require someone to go on annual leave for 5 days, you must give them 10 days notice. You must always remember that you can never order people who are off sick to take annual leave instead. However, some people might prefer to do exactly that, given the rate of the statutory sick pay entitlement. You can still technically cancel employees' pre-booked annual leave, but you should only do this in very exceptional circumstances because it not only damages your relationship with your employees, but you might also be liable for your employees' financial losses if, for example, they have to cancel their flights or hotel bookings. If you do cancel your employees' pre-booked annual leave, you must give staff at least the same number of days notice as the original holiday request. Employees might be understandably upset when pre-planned leave is cancelled, so you should always try to be as flexible as possible and maintain good communication with them. Looking at the emergency legislation, which was introduced recently, under it, it's now possible to carry over up to 4 weeks of annual leave if it was not reasonably possible to take it due to the coronavirus. Carried over leave entitlement can be taken in the next 2 leave years. And you should keep in mind that employees can still take the remainder of the annual leave entitlement, which is 1.6 weeks during the leave year in which it accrues. But you can also allow for it to be carried over as well under your own policy if you decide to implement one. In terms of the factors that you should be looking at when deciding if it's reasonably possible for someone to take annual leave, you should consider factors such as whether your business faces increased demand, which requires the employee to continue working, whether the employee in question is sick, self-isolating, or furloughed, and how soon they need to be taking a period of rest and relaxation. You should also look at the extent to which your workforce is affected by COVID-19 and whether cover is available for absent employees. You should consider the length of time remaining in the employee's leave year and the ability of other employees to provide cover for the employee going on leave. In terms of how annual leave is actually carried over on a practical level, you might, for example, decide that carried over annual leave should be taken within the first 3 months of the following leave year. Any such decisions must form part of your policy, which is clearly communicated to employees. You should allow employees to take leave at the earliest opportunity and allow them to take whichever entitlement expires first. The last thing I think to remember in terms of the emergency legislation is that it doesn't actually affect any existing internal or contractual arrangements that are already in place. I will now hand over to Julie again, who will look at the annual leave and the quarantine rules.
Thank you. Alex. That was really useful. I've just got one. I know we're just over time, but one question that came into us before we actually started this and when we advertised it was issues regarding quarantine rules. Now, I've got my fingers crossed that the mandatory quarantine rule is going to be abandoned within the next few days, because let's face it, we all need some good news. Certainly me, having this IT nightmare this afternoon. But just in case it isn't, and just in case it comes up, and now the Foreign Office has advised against all non-essential travel. So basically, there's no good reason why your employees should be travelling except for what would be classed as essential travel. And essential travel isn't particularly defined. And therefore, if this quarantine rule continues, we suggest that you have a consistent policy about how you're going to treat the period of quarantine on someone's return. Communicate that policy effectively before people go away, before people plan trips. Specify what you class as an essential trip. And by that, it could be such matters as compassionate leave, so going abroad for funerals or to see family that you haven't seen for the last 3 months, let's face it, as opposed to going on a stag do. Consider how you will treat quarantine depending on if you class it as essential or non-essential. If you're going to ask employees to travel for work abroad, you've got to ensure that you're happy that you can still provide a safe place of work. And that commute, if they're travelling from abroad, amounts to the workplace in many respects. You've got to take that into account. If you're looking at these trips and the quarantine thereafter, obviously the trip itself will likely to be taken as annual leave, or in some cases, I guess, compassionate leave. But the period of quarantine after, you need to decide whether you would treat people differently if they can work from home, as opposed to those people who are unable to work from home, and whether you ask them to take additional annual leave to use up some of the leave that they've accrued, or whether you ask them to take sick leave because they are self-isolating and such they may only be entitled to statutory sick pay, or whether you tell them that they've got to take unpaid leave. You may also want to consider whether you consider it is a disciplinary offence to go on non-essential travel during this period of time, knowing that they're going to be unable and to work for 2 weeks thereafter, and therefore affecting the workplace.